And your name, sir? Good morning or good afternoon. As I was heading to my chambers just now, I was handed a sheet, a paper that you wrote to me, and they said that you didn't want me to share it. If I read this, I have to let the defense see it. I want you to know that. So you understand I'm going to read it.
If I have just one moment.
This is an email that was sent today, it looks like, at 1:00 and 51 seconds. It was sent to Laura Dodge.
Your Honor, that is the statement, the victim impact statement that we,
So what I'm trying, I get it. Hang on.
Yes.
What I'm trying to tell everybody is I can't have secrets here. So I will, if I'm going to read this, he has to understand I'm going to let the defense, I'm either going to read it out loud so they can hear it, or I'm going to give them an opportunity to read it.
Your Honor, he did not want to say it himself. We asked that the court say it. So
It's fine.
you may read it aloud.
Okay. So your client pled guilty to domestic violence under 76948. And this is the page that I received. Your Honor, thank you for allowing me to speak. My name is Anthony Malmston. I've been with Mindy for 25 years and experienced over 2 decades of verbal, emotional, financial, and physical abuse. Looking at the past year alone, there have been 5 domestic violence incidents involving me and our 3 children. She's caused fear and instability for our family. The children were present during all of these incidents and were physically and emotionally affected at times. As a result, the children and I are in long-term therapy and receiving ongoing treatment for complex PTSD stemming from years of abuse. I am not here for revenge, but to ask for meaningful accountability. Given the number of incidents and the impact on our family, I believe the proposed sentence is far too light. I respectfully request a comprehensive mental health evaluation, mandatory anger management counseling, and regular drug testing. I also ask that she follow any doctor-recommended treatment plan, including remaining compliant with prescribed medications, which has been an ongoing struggle. Our family has relied heavily on First Step for support and counseling services. I ask that she be required to contribute to the Victims Fund to support future victims, John. I also request that the no contact order be upheld, extended, and strictly enforced, as she has been accused of violating it 3 times in the past 6 months. My priority is the safety and stability of my children and family. I ask the court to ensure accountability along with the appropriate treatment. Thank you. Ms. OWI, correct me if I'm wrong. There was no alcohol involved here, was there?
I'm just going to take a second to confirm.
Please. I read the report. I do not remember seeing any mention of alcohol or drugs being involved.
There was no.
So that, just so everybody knows, I don't order that kind of a no alcohol or drugs unless it had something somehow, some way to do with the incident. There's no indication that it was here. Have you had a chance to review the screening and the pre-sentence report with your client? And are there any material additions, corrections, or deletions?
Yes, Your Honor. So I guess one thing to address is we placed this, I know we came in on Zoom kind of last minute right before the trial to put this on the record. At that time, the offer that was tendered was 7694A for a 6-month probationary period. You said you would go along with that. You actually brought here the victim in this matter, and he said that he was in agreement with that as well.
Did you have a 6-month agreement on this?
Yeah.
I don't usually do sentence agreements. I can tell you that. Okay, that's what you're recommending. Did you take that as a sentence agreement?
Well, yeah, well, yes. And then when you said I'll go along with
Let me
it,
go listen to the tape. If I said, yes, I'll go along with it, I'll go along with it. I'm gonna go listen to the tape. We'll pull out the log notes. So you guys will have to be seated for a few minutes while I go on to a couple of one of these. I don't, I don't do those.
And I do know she said it was a recommendation. She said that and then Miss Holloway, sorry, I apologize, said that this was our recommendation.
And I said,
We'll go along with that. And then we took the plea. You asked Mr. Mulligan.
I don't want you telling me how many months I'm gonna do anymore then. Will you do that for me? Usually I do less than you guys ask, but I'm not gonna do less when you guys put down 12 if I can't do more when I think it might justify more. I'm not saying it does or doesn't here. I got a lot of questions in my own brain here, like a 26-week domestic violence program. I don't have that in my brain. This assault was not serious enough. Not that any domestic assault isn't serious enough. But I'm not ordering 26 weeks domestic violence batters counseling when there's a simple push. I'm not doing that.
Made recommendations as per your request, so I will be.
Well, my request is always leave it to me, right? I want to be able to be the sentence. I don't do cops pleas. I haven't done cops pleas since 1995 or 6. And I'm not starting today or anytime between time now and the time that I leave. So if you really were that insistent on 6 months, I'll go listen to the tape, but you guys just have to be around here.
It's fine.
No. Is that what you want me to do?
I would like you to listen to tape because outside of all of that, Your Honor, and is the negotiations between me and Miss Holloway.
She's not the prosecutor, or she's not the judge.
I understand she's not the judge. I got that.
So that's what I was saying, is when lawyers start telling me what they think of do, and I'm not gonna go along with these sentence agreements. This is silly.
I understand, but what I was.
So I'm cutting it both ways here. I'm not gonna go along with the 26-week recommendation because it doesn't merit it. But if I think more than 6 months is merited, I don't want some lawyer telling me you or anybody else, you agreed to 6 months. If I agreed to 6 months, I'll honor 6 months. But it's gonna just take us some time. My regular recorder isn't here. My regular recorder isn't here. I'll be glad to look at it. If I said I'll go along with that, I might have meant 7694A. I gotta listen to the context.
I mean, my memory is good, not. I remember you saying that. I guess
You want 6 months, probation recommends 12. That's where we are.
well, I think if you could pass it for 2 minutes.
I'll be glad to do
Let me
that.
talk to my client because I think I think she has a different concern really than the length. So if that's the case,
I'm gonna be fair with her.
I don't dispute that, Your Honor. I've been in front of you for 13 years.
I know, okay, you can talk to her, but honestly, if I said I don't want anybody to walk out of here thinking that I'm gonna change my mind without offering them the opportunity to withdraw the plea. So if I said I'll go along with 6 months probation, then I'm gonna go along with 6 months probation.
No, absolutely.
You know?
I fully understand that.
Okay,
Just give me
have a conversation, take your time. I'm gonna real quick take Rakeem Deshaun Gadsden, 25F244729. Flat Rock's here this afternoon.
Yes.
All right. Come on up here, sir. Your name? You're charged with driving on a suspended. You have the right to a lawyer. Do you want a lawyer?
Yes.
Where you been? Why is it taking you 6 months to come in here? I'm gonna give you a lawyer. You can talk to your lawyer about what you're gonna tell me as to why you were so late. We're not a restaurant here, okay? Got it?
Yes.
I'll give you a lawyer. Flat Rock prosecutor's here, right? Yeah, I saw Mr. Keeley. All right, we'll set you up with a defense attorney. Go out in the hall. He'll set you up and you'll be all set, okay? Summer Greathouse. Summer Glory Greathouse. 25F245336. Give me 1 second, must be wrong. Tim. All right, your appearance, ma'am, your name? This is going to be a plea to operating while visibly impaired, correct?
That's right.
They're going to dismiss the operating while intoxicated, correct?
Correct.
Correct me if I'm wrong, somebody dropped the ball here. This is at least your third drunk driving. Right?
It's true, but the first two is she was in her early 20s.
I'm just telling you what the law is and what I see. I mean, I've seen them enhanced from 2002, 1996. I don't write these laws. They don't talk to me about them. But I want her to understand they could have charged a felony. And I want her to understand if you don't get into sobriety court, you're going to go to jail on this. Do we understand one another? So does she understand that? Have I alluded?
She does.
So you understand what sobriety court is? Could you talk to the sobriety court probation officer?
Ms. Wilds?
Yes. So you understand that when we do this now, I'm going to put you on a bond conditions. She's going to put you on bond conditions, essentially. You're going to start going to treatment. You start testing 3 times a week at your own expense. You're going to have a sober link device, which you already have. I believe I would have ordered that. If I didn't, I dropped the ball. She has a sober link, right? You're going to be going to AA. You're going to have to come to status review hearings with me every other week. And in the off weeks, you're going to have to meet with probation. This will go on for 2 years. We'll put you through a bond phase. And after about 5 weeks, the team will meet. We have defense lawyer, prosecutor, treatment specialist. We're going to decide whether or not we're going to accept you. And if we accept you into the program, that's great. I'm not promising I won't send you to jail if you get in, but I am promising you I will send you to jail if you don't get in. Do we understand that? You still want to take this plea? I'm just trying to be upfront with you here. Do you understand everything? If you plead to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all 4 points, license suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? And did you sign, read, and understand an advice or rights form here today? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? Any questions before I go on? To the charge operating while visibly impaired, how do you plead?
Thank you.
On December 11 of 25, were you operating a motor vehicle on East Trent River Drive near Sheets Flat Rock at 11:53 p.m.? Prior to that, did you drink alcohol? And if so, what did you drink and how much? I need you to keep your voice up.
Was drinking White Claw, and I probably had 7.
And what else? What else did you drink? Nothing else? Just 7 White Claw? You were pulled over by the police, correct?
Yeah.
Why?
I'm not sure.
Do you think you did anything wrong in the operation of the vehicle? Were you swerving, weaving? Was there an accident? Did
It
you,
was not an accident. I may have been swerving.
do you think you were swerving?
Yes.
Do you think you were swerving at least in part because of your alcohol consumption?
Yes.
Was this was a blood test, wasn't it, counsel?
Yes, ma'am.
Do you stipulate that the reading of 0.271 was an accurate reading?
Yes,
Are you on probation or parole right now?
Yes, sir.
Anybody force you to plead guilty? All right, please accept the operating while impaired. The OWI is dismissed. There's agreed upon costs of recovery of $225. I'll make a note that this is going to be sobriety court. We're going to do a screening and assessment. Now, I'm going to order that your vehicle be immobilized as I must because you got a prior 2 years ago, 2.5 years ago. So I have to order a mobilization of your vehicle. So you're going to have to call a company. We're going to give you the order. And it's going to put, you're going to have, I'll give you the minimum. It's 90 days. So you're going to have a club put on that steering wheel within 7 days by March the 10th. We'll prepare the order down the hall. Make sure you get that. Now, I'm not excited about the fact that you were drinking in violation of the bond conditions. I'm gonna let that go. But you gotta get back up. You're gonna die if something bad, this is crazy, okay? You seem like a nice lady and all that, but you gotta get your life in order here, okay? So we'll do it through sobriety court. You're actually gonna enjoy the program if you embrace it. If you don't embrace it, if you're fighting it the whole time and going home every day saying this is miserable, I'd rather spend 365, actually 730 days in a dentist's office getting root canals every day. You follow me? So I need you to embrace it. If you go through this bond phase and you say, I just don't want to do this, that's fine. I just, there's going to be severe consequences to that. But I wouldn't go through sobriety court to send to just appease a judge or my spouse or my friends or my parents for 2 years if I thought it was the worst thing in the world and I wasn't intent on getting myself some lifelong help. And I'm being honest with you. Okay? Because the whole concept here is we got to get you away from this because, you're only what, 38? Three's a lot. If they'd have enhanced this, there are judges in Detroit that would have sent you to jail. You were convicted of a felony. A lot of them, okay? So I'm just telling you. So we'll give you a sentence date. You get the immobilization order. Let's get going. There's no reason for you to be scared. Just embrace the program. Believe it or not, I'm on your side. Okay? All right, give me a date if you would.
Judge Hubbard, did you want this out a few weeks?
Yeah, I'm gonna think like the 12th or 14th or something like that of April, around there.
Okay. And you have sobriety court on April 15th?
Perfect. We'll make it at 8:30,
On April 16th, Your Honor.
15th. You said 15th, right?
Correct, Judge.
You can't do the 15th? What if we do the 14th? Can you do the 14th?
I think so.
Let's make it the 14th at 8:30. The more that we put it out there, the more she has to pay for her own testing, Sober Link and that kind of thing too. So I don't want to go any further than that. Okay? You all right?
Thank you.
All right. Thank you both. Good luck. All right. Come on up. What do you have, Mr. Mays? You got something?
Teasdale, Your Honor.
Is that a real quick one?
Yes.
Where's the file? You have the-
Prosecutor brought it in, I thought.
Okay, give me 1 second. Did you figure out what you want to do? You want me to?
Yeah, we're gonna proceed.
You sure? Because I'll go listen, and if I said that, I'm telling you, I will not go back on my word.
I told you about that, but
All right, let me talk. Lauren Rose, Louise Teasdale, 25F245343. Good morning.
thank you, Judge. William Mays, on behalf of Ms. Teasdale. Ms. Teasdale, say your name.
Is this a first offense?
Yeah, and
She's-
we're still waiting on discovery. We had a pretrial a few weeks ago. I'm gonna send over an email to remind the prosecutor.
All right, so second, all right. Pretrial date, couple weeks out, March 17th, good?
I know I got some stuff that day, but let me,
Are we going to trial
Judge.
on this, Mr. Mays?
nope, what?
Are we going to trial on this?
I think, no, it's just a question as to how generous an offer the prosecutor's gonna give me.
Judge, it would be March
Yeah, right.
19th for Flat Rock.
March 19th,
Oh, 19th. 19th I can do.
8:30.
Oh, 8:30?
You want me to do 9?
I thought we were doing afternoons.
I don't do afternoons.
It's,
I am today because I'm gonna be out of town tomorrow. We had to reschedule the docket.
no problem. Thank you, Judge.
Can you do 8:30?
Yeah, I can.
Okay, 8:30 on March 19th. Did I already sign your discovery order?
I don't think it even required an order. It was just a demand.
Good enough, good enough.
Thanks, Judge.
Go, take her down, she'll get her
And
notice.
now I'm gonna start to ask for cops.
No, I
How
don't-
did I hear this?
I-
I'm gonna start to ask one.
I said I don't do
Oh,
cops.
that's what I want to ask. Thank you, Judge.
Mandy Lane Malmston, 25B722119. I need your appearance too, Ms. Holloway.
That's Nora Holloway, Department of Legal, PA 6528.
Ready again, Your Honor.
All right, come on up here. Your name, ma'am?
Mindy Malmston.
All right, counsel, your appearance.
Nicholas Darren, the defendant who stands my record.
All right. You've reviewed the report, right?
I have, Your Honor.
Any material additions, corrections, or deletions?
No, I just have some things to say.
Sure, go ahead.
So, Your Honor, this is, this all has arisen, and there's a relatively nasty divorce case that's going on as well alongside this. This case in conjunction with, I don't litigate the whole divorce case, I'm sure you've seen this enough times. There's been issues with the minor children, people not following orders, houses are being ordered to be sold, things of all that nature that have, you know, pumped up the animosity in this case, as well. Your Honor, I think you nailed it on the head, when you looked at the report. I would say the video is similar with the officer's conversations with the victim in this case. I agree with you. I don't think that the 26-week domestic violence program is necessary in this one. There was a order in the family law. One thing we did discuss was contact pursuant to the Third Circuit Court, because there is orders in place that allow her to see her minor children. I'm not even gonna get into how that's been going because of various outside factors, but Your Honor, at this point, these parties are essentially electricity and water. If my client said the sky was blue, the victim would disagree. If the victim said that water is wet, my client would disagree. Me and the counsel in the divorce case are doing our best to try and bring some sort of sanity and semblance to this case. They've been urged by the Third Circuit Court judge to try and put down their swords and come to some resolution. We are going to mediation, I believe later this week or early next week, with where I have hopes that we'll reach some sort of settlement in this matter. I'll be honest, Your Honor, I don't think you're gonna have any problems with my client on probation. She has no prior record of any kind. I think she's gonna be a model probationer for you. I think she'll be in compliance. She works full-time for the United States Post Office. And she wants this behind her as much as possible. She wants to move forward. At this point, she's come to some realization with the other case that there has been damage done that's only time will heal. And no matter what she wants, it's not gonna happen at that certain rate. So, Your Honor, I just ask that you obviously make some corrections to the recommendation, but I do believe that whatever term you place her on probation, this will be the last time you see her. I don't think there's going to be any issues. These two parties, I understand that there's a request for a no contact order, but these two parties are going to share legal custody of these children. They're going to have to communicate about these children. They're going to have to communicate to do parenting time, to do exchanges if something happens to a child. So if this court continues and just does a flat no contact order, I'm sure you'll be back. You'll see Mr. Malmsteen come in here and say that there's been contact because, oh, my client went to the school or something like that to see her kids and he was there. Or, oh, they had a conversation because the child was sick and she needed to relay that information to him. So I just, as I'm sure you've seen countless domestic violence like this before in front of you where there's a pending divorce case and you understand the heightened level that the parties give it. But at this point, Your Honor, my client, like I said, will be a model probationer. I don't think there'll be any issues. And I ask you to follow the recommendations with some of the modifications as I had mentioned and you had mentioned previously.
Can I ask you a question, sir? Do you mind coming up here? Or would you rather not? Come on up. Your name? I'm looking at this report again, and there's like a supplement that talks about Norco and Adderall.
Yes, for the last 10 years, Mindy has made me give her half of my medication every day,
That's not true.
which is illegal. Yep. She's suffered from many alcoholic and drug problems throughout the 25 years and been in treatment.
Have you been in treatment?
No, sir.
Your Honor, she reported to your probation department that she's with Dr. Yee and that she gets a medication. I mean, that's not, I didn't correct it because that's what it is. I mean, she is openly disclosed that. So again,
I've seen Dr. Yee for 10 years.
Your Honor, like I said, this one hits my top 10 list as far as divorces in 15 years. So, and I mean, we can, like I said, I'm not really interested in litigating the case on the whole thing, but she hasn't seen her kids since this incident. And
Your Honor,
there's, go ahead.
if that's in the report, I have no objection to a recommendation for treatment. I don't see any harm in an evaluation.
But what's the treatment? She's already with someone who she's been treating with for 10 years.
Well, I'm not worried about that. She's gonna continue to treat with him. That's not the issue. I don't even need a psychological evaluation. I'm concerned about this additional interview that I'm just seeing.
But, and if it's the additional interview, I'm thinking that's when he came back to the police department after the fact to then info dump an additional set of facts, which I'm, again, out of respect for him, I'm not going to bring up most of them. So, Your Honor, like I said, there was an arrest. There was this report, which is the initial report. And then he comes back with the eldest child, who him and her have been in here at every court appearance, posting on Facebook, taking selfies in your courthouse about how they're here to put and take care of the wrongdoer. So, I mean, Your Honor, like, when I say top 10, I've done thousands of divorces. It's everything.
All right,
Rightfully made a report. We went back and made other reports, so that, I believe what you're looking at is a part of other reports. Or other reports were made from that supplement. So if there are allegations to that, again, I don't see any harm in an evaluation, and I would have no objection to your recommendation for that.
I'm talking about abstaining from the use of alcohol and drugs. I don't see any incident where this was involved in this incident. In other words, I don't see any reference in a report where she was under the influence of alcohol or drugs or both at the time of the incident. He didn't say it then. He's talking more about past history. What I'm gonna do is this. Do you have anything else you wanted to say?
Just that I did review the PSI. It does say 12 months. Nick and I did speak about, or Mr. Darren and I did speak about 6 months. But for the record, I have no objection to the court following the recommendations of the PSI. If we so choose.
How old are the children?
They're the eldest is 21, and there's 14 in.
I don't care if they're 21, 14, 8, or 56. You guys cannot get your children in the middle of your issues. You cannot do that. That is so incredibly harmful to a child who loves, I'm certain, both of her parents or his parents. You cannot do that. I don't care how much you want to do that. I don't care how much satisfaction you get out of turning a child against the other parent. And I'm referring to both of you. You cannot do that. That cannot happen. I'm not talking to anybody in particular here. I'm just talking to both of you. 9 months probation. If I let you finish, did you want to say anything else?
No.
I mean, if there's one thing I've agreed with is what Mr. Darren said about the circuit judges, including them to put or encouraging them to put their swords down. You cannot do this, folks. Okay, so you're not happy. People get divorced in this country every single day. Not just one couple, probably thousands. I mean, I don't know what percentage of marriages work to the point that they last forever, but okay, so you want a divorce. I get it. Maybe one of you do, maybe both of you do, maybe both of you can't stand each other. You cannot harbor ill will toward the other in front of your children. It is damaging. 9 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify the probation department. You do have to report as directed. I'm going to order that you continue your mental health treatment at the facility approved by probation. I'm going to order that you attend the domestic violence weekend program. This assault doesn't rise to that level of requiring 26 weeks. No contact with the victim except to effectuate visitation with the minor children in accordance with the order of the Wayne County Circuit Court. I can't believe, is there an order sharing custody at least right now?
We,
Did you guys have a hearing on that?
we haven't had I filed a motion for parenting time and Judge Farr had just ruled and ordered parenting time and joint legal custody and said this, and then sent us to mediation, which is at the end.
So you got, there is an order from the
Yeah,
circuit
there's a
judge.
work for parenting time and.
Okay. So you got, there's to be no contact except to effectuate visitation. I would like to think you two are adult enough where you can at least communicate with one another. I'll pick them up at 6. I'll drop them off at 4, whatever the case may be. But that's the order of the court. You're not to possess any firearms. You're not to possess any dangerous weapons. You're to serve 4 days jail credit, 1 serve 3. I'll let you serve those with community service. I'm going to give you till April the 30th to complete 24 hours of community service. We're going to give you a prosecutorial review date here in a minute. I'm going to order that you pay fines of 100, cost 200, 75 victims' rights fee, $50 justice assessment. So fines and costs are 4.25. Probation fees are 180 for 605, and then you have screening fee of 60. I'm not going to order the court work program. 665, if you violate, your probation could be revoked. I'm taking it under 7694A, as I said. If you comply, the case will be dismissed on motion of the prosecutor. The only agency that will be able to see that are police officers, judges, prosecutors, nobody else. It'll be a non-public record for all time. If you're compliant, the case is dismissed. If you violate, you can become non-public. Like I said, your 769 status could be revoked, and then it will go on your record for all time. So, do we understand the sentence? Anybody have any questions?
No questions here.
Can she pay that today? 665.
A couple hundred today, Your Honor, but we should be able to get that taken care of, within 30.
I'll just give you till April 15th to pay it. Can you do that? You pay 200 today and then the balance by April 15th. You'll meet with probation. Give me the review hearing date, if you will. Heather. So it should be out in
December 3rd. I'm sorry, Judge, I was muted.
December 3rd of 26 at 8:30. You don't have to come, Mr. Darren, if she's compliant. Okay, anything else? Did I miss anything, Ms. Dowling? Mr. Darren, anything else?
Nothing further. Your Honor.
Ma'am, anything else? Sir, anything else? And I wish you guys well. I truly do. Hopefully, you're gonna recognize children are much more important than we are. Good luck. Thank
Do
you.
you want me to take her to probation first or?
Yeah, take her to probation. Thanks.
Thank you.
Christine Francis